Hello, and welcome to the May edition of LLFtv, brought to you by the Landlord law firm, Landlord Advocate. My name is Robert Chesson. I'm the managing partner here at the Landlord law firm. We're glad you joined us this month. This month we're going to focus on the second of a three-part series that deals with the eviction timeline. We talked about what happens when you get to the courthouse last month. This month let's talk about what happens before you get there. We're going to focus our conversation on non-payment cases. As many of you know, non-payment cases in Connecticut are the simplest, most effective way you can enforce your lease if you've got a tenant who's not compliant. So we're going to focus on those for this conversation. In your lease, you've established a due date for the rent. Whether it's the 1st, the 15th, whatever your lease says, that's the day the tenant's supposed to pay their rent. In Connecticut, by statute, the tenant has a 9-day grace period after the due date in your lease, during which they have the opportunity to pay the rent and still not accrue either late fees or the possibility of getting a notice to quit. Once that 9-day period has expired, it's time to start legal action, or at least your right to do so has accrued. You do that by serving a notice to quit. One thing to keep in mind about serving that notice to quit is if your tenant has either paid or even offered to pay before you actually serve that notice to quit, then it's not going to be effective and it does not protect your rights to enforce the lease. So, if you're serving notices to quit, serve them timely, because in effect, it's a race between you and the tenant in the instance where you're looking to enforce your lease. What that notice to quit is going to do is it's going to tell the tenant that because they didn't pay the rent, they have to vacate the premises. Now, sometimes, although rarely, the tenant will actually vacate the premises in response to that notice to quit, in which case you enforce your rights under the lease and you now proceed as you wish to deal with that unit. However, most oftentimes, the tenant doesn't actually vacate in response to that notice to quit, and you actually have to take the next step, and that is the service of the writ summons and complaint in court. That writ and complaint in court is actually seeking a court order that you can remove the tenant from the premises because they failed to pay their rent on time. Those are the steps that you need to follow in order to enforce your rights, or at least have the opportunity to enforce your rights in court if you've got a tenant who's not paying on time. Now, in order to allow the marshal enough time to get the notice to quit served and get it back in a timely fashion, and also serve the writ and get it filed in court in a timely fashion, you should expect the clock to start ticking on the defendant to actually do something in court in about 21 days from the time that notice to quit is sent out for service. So, those simple steps are the process. You should be looking at about 3 weeks worth of time and effort in order to get that process completed. And then we lead into what we talked about last month, which is once you get to court, what happens next. Thanks for joining us. I hope this was helpful, and stay tuned. We've got another video coming with current events and news around the landlord community. Again, my name is Robert Chesson, the Landlord Law Firm. Appreciate you joining us. Look forward to seeing you next month.